If you don't know me, hi, I'm Kelley. I'm CEO of Clinical HR. I've been an HR advisor for dental practices for like 12 years now, which makes me sound incredibly old, but it's been that long, apparently. So I met Carrie through Dental Nachos, and we met at Women in DSO and kind of got to talking and enjoyed our conversation so much that we're like, we need to have this conversation in front of people. This is a good one for everyone to hear. So this is just going to be kind of like a free form evening of us talking about the things that we do and the things that can help you protect your practice. Carrie, you want to introduce yourself?
Yeah, absolutely. So I'm Carrie Millar, and I am the Vice President of Business Development for Dentist Insurance Services, which is a national commercial insurance broker that only does dental offices. I do I actually speak at dental schools a lot. And so I go all the way from when you graduate until you retire. So that's what I've done. And I have my undergrad is in risk management insurance. And then I am also a certified insurance counselor. I have my CIC and my MBA. And I've been doing this for 19 years. So I actually started with dentist insurance services as my first big girl job, is what I'd like to say. And I started at the beginning, and now I have a team of 25 under me. So 25 of us have about 12,000 clients nationally. So that's what we do. And so, yeah, we're happy to be here.
And
And
you're
I
the
think
person that everybody needs to know and nobody ever wants to have to talk to because we don't ever want to have to use the insurance, but we need it.
correct. Absolutely. That's exactly what it is. And I like to say that I'm a share person. Like I just want to make sure you understand what everything is and what it is. And then if you decide you want it or you decide you need to have it, I'm happy to advise you on it. But we hope that you never use the insurance, but in case you need it, you want it to be there correctly. So
I was just talking to my client, funny enough, who's about to enter the room. I was just talking to my client about this. I was doing a handbook meeting and we were talking about EPLI insurance. And he asked me a question, and this is actually, it was so timely that we're having this conversation right now, because what he was talking about was how he had just worked with his broker, and the broker was making recommendations about how much EPLI he needs. And he asked me if I had an opinion on that. And I'm like, that is not a me question. I'm the person that helps you not use the EPLI insurance. Hopefully, fingers crossed. Not that none of my clients that I'm aware of have ever needed to use theirs, but that is a great question, I think, to actually start with, Carrie, is maybe talk about what EPLI is, and how that can help protect their practice. And is there a recommendation for how much they need per how many employees they have, or revenue size, or I don't know, you tell me, because
yeah,
I'm
no,
curious myself.
absolutely. That's exactly what it is. So you have insurance for every different part of your business, and so the employment practices insurance, or what they sometimes call EPLI or EPL, basically is the liability and the defense costs if you have any type of situation with your employees outside of a work injury or a work illness. So any kind of harassment, wrongful hiring, wrongful firing, wage and hour is a big one. So any kind of disputes is when that comes up. If people allege anything, that's where that liability insurance is going to come in, is under that employment practices liability. And you are right. Sometimes it's on your office insurance for $10,000 worth of coverage. And sometimes people have $1 million or $3 million policies. And so it really depends on what state you're in. If you're in a very highly litigious state, you need to have more insurance. That's actually bigger probably than, and then what size you are, so what you want to do is, how many employees you have, what your risk potential is. If you have a lot of employees, we like to say that you need to have at least 10,000 in coverage for every employee. That's a really good baseline. However, if you have a lot of higher salaried employees, that would suit that their lost wages would be higher, you might want to have higher coverage. And if you've had any type of claims in the past, you would also want to have higher coverage. So most of my clients have between 250 to 500,000 per office location.
Can you name maybe some of those litigious states? Because I think I know a few off the top of my head. I know some of the ones that are not fun from an HR perspective.
Yeah.
But I also know that, like, I think it was in 2021 or 2022, something like that. Like Texas had something like 10% of all EEOC claims, for example. And so
Yes. Yes.
that's the kind of thing that falls under this. And so I'm kind of curious if there are some that are more litigious than others.
Yeah, there are for sure. And it's different parts of different ones. So Florida's very litigious. It's definitely South Florida is more litigious than the rest of the state. It's funny because pricing definitely varies in Dade, Broward, Palm Beach, County area, it's very litigious. New York is very litigious. Georgia has become very, very litigious lately, just because of how their Supreme Court has ruled on a few things. So they are very litigious. As you can imagine, California sides on the sides with the employees a lot and not the small business
No.
owner a lot. Yeah. So that can be very litigious. Their laws are also very strict on the wage and hour. And I think that you could talk to that. I actually talked to a customer, one of my clients today, who was talking about, what's the difference between Texas and California? And I said, oh, no, that's not my specialty. That's Karen's specialty, because it's daily overtime there, correct? In California?
Well, so there's actually 4 states that have a daily overtime. California is one of them, Nevada and Alaska. All of them are if they work more than 8 hours in a day, and 40 hours in a week. It goes either or. Colorado is the other one, and that one's actually over 12 hours in a day. So of those states, that's one of the reasons, like when I look at handbooks, I want to make sure that I'm using policy specific to the state, because while most of the states operate a certain way, some of them don't, even on things you would think would be pretty standard like this. And I actually did a post on Facebook probably about 2 months ago at this point, where I had reviewed a handbook, and it was for a client in Illinois that they had an attorney in Nevada give them this template. And I'm reading through it and I'm like, this attorney didn't even, and this attorney, not like random person or office manager in a Facebook group, did not even change the overtime rate. It was still reading how Nevada read, and Illinois doesn't have that. They have a lot of other things that weren't included in this, but they did not have the correct overtime calculation. And so this client would have been overcommitting to following the overtime more than 8 hours in a day if they would have kept that. And I actually think that they are continuing to keep that for various reasons. But you want to make sure that you are using policies that apply to your state. Otherwise, you're going to be in for a lot of problems.
So they just like legal Zoom a handbook and download it?
Yeah.
Okay. That's definitely one way to
I don't
go.
know what they did. It was an actual law firm. It really was. I don't know why this law firm is handing out this template. It was very concerning, but anyway.
Yeah, I mean, I think that's a conversation when you have a professional that works for you, and the professionals that work for you should be extensions of your team. Like, you should consider them another member of your team, especially if you're a small business. You don't need to be a jack of all trades. You just need to have an expert that you trust, and you need to have one that
team.
Yeah, that understands your business. So, we get that a lot because, we just do outpatient medical, just dentists. And so a lot of times people will say to me, oh, well, I don't need that because this. And I'm like, no, that's there. We've had several claims that way. So, but,
well, if you're talking about root of the risk, that is one of the things that does pose such a problem, is a misunderstanding of whatever employment laws apply to your state. And mind you, neither of us are attorneys. We're not giving legal advice on this call. This is for informational purposes only, just based on our, combined almost 40 years of experience, it sounds like, or upward of 30 years of experience. That is one of the biggest issues that I personally see, is that they're using policies that don't apply to them, that they borrowed a handbook from a friend, from somebody else's practice in a different state, or even one that's in the same state that might have a different head count that applies differently. Depending on what you're looking at, states by state might have something that is different than what the federal has. And sometimes the county or the city, the locality, has something different than what the federal shows. So your head counts may be all over the map. And you talked about California. California is one of them that, like, as soon as you get 5 employees, all of a sudden you have like 20 different types of leave that apply to you.
Yeah. 100%. And then you also have, dentists that come in and buy practices from other dentists that are established, and you just use their handbook and you don't know who made it or when it was, and you just cross out their corporate name and add your corporate name, and or you become, you start as an associate and you buy into a partnership, and as you buy in, you just assume that the person that you're now partners with had that taken care of, and that's not the case. So it's never something you want to sit down and do, but it is something that you should do annually, is sit down and your insurance agent, whoever they are, and again, whoever you use, you just need to trust, and they should sit down with you annually, or at least offer to, and go through all the different stuff that you have and make sure that's what you need.
Yeah, to absolutely protect you from some of these things. Now, I mean, because you can be doing everything right and employees still can come back and sue you. Everybody's entitled to file a suit. They're entitled. The EEOC, the DOL, IRS may pick it up, but they're entitled to go and do that. We have people.
Yeah, they're entitled to file the claim for sure. There are complaint. obviously they can file those complaints. You can be made aware of them. It's not a fun thing when you get that, but that's why you have the insurance in place so that you know what to do. You have your attorney gets involved, the attorney for the insurance policy gets involved right away. So you have that peace of mind. And then it's up to you whether you're going to, sometimes they just want a settlement. You can decide whether you want it. Most insurance policies you want to make sure that you have the consent to settle agreement in there where it's your right to settle if you want to and not the insurance company's right. So those are some of the things to look for in a policy. What you don't want to do is just lump it in with your office policy and just say, oh, look, it says employers practices. I have this. And it's like, oh, well, you have $50,000 in coverage with a $25,000 deductible. And you're like, well, that's not really coverage. That's just a warm fuzzy that's not going to be there. So,
ouch. I'm sure you have stories about that. What's the most that you've ever seen somebody have to pay out in an EPLI case?
So we've seen some big ones. We've definitely seen some big ones, but as far as small practices, about 100,000 is on average. 50 to 100,000 is what we see. It's a lot of wrongful termination, and the ones lately have been a lot of toxic work environment. So it's normally employee attitude / crime, I guess you could say. So it's that it's not typically the dentist that's involved in it. It's the front office and the back office, or it's two hygienists, or for whatever reason they're not getting along. And because the dentist didn't, or the office manager didn't intervene and didn't reprimand correctly, or somebody felt like they had to quit and leave, that's where we're seeing a lot of the losses right now.
That can also lend into what something's called hostile work environment, which I know that word gets thrown around and there's actually a legal definition to it. And it's about discrimination based on your membership in a protected class. And so sometimes you'll have that where these two don't get along. And on the surface, it sounds like, oh, this is just high school nonsense. This is just dental team drama. But the person who's being harassed is in a protected class, and then they can go and file for hostile work environment and say that they're being harassed because of their membership in the protected class, which just escalates it to a whole new level.
Yes, absolutely. That it escalates it to a whole new level. And as much as that was never the intention of what the conversation was, that's where, it gets put. So, and we've seen frivolous ones too. I mean, I've definitely have had situations where people have been let go after, very well documented situations, and they continue to bring complaints one after another. And so we've had a situation where they basically were harassing the ex-employer, and we had to get, intervene that way. And that's what the insurance is for there too. So they were posting, very mean reviews online of the practice, and just really vindictive.
And so you've gotten involved from that side to benefit the employer?
Yes.
Help stop
Yeah, the employer's liability will get involved in that side of it too, just to basically a cease and desist and that kind of thing. So yeah, it does work both ways. Now, normally it's just the one way that we see most of the time, but yes, that is in place.
Is there a different level of a deductible for something like that versus like an actual lawsuit?
Yes and no. I mean, all the different sublimits have different deductibles, but normally the retention is about 5 or 10,000, just depending. So there's also what they call third-party liability claims. So that's a situation where it is either a patient that feels like they are being harassed, or a vendor, or a contractor, or anybody else that would be in the office as far as in that situation. And so that's typically a lower limit, but the deductible with a separate deductible.
And some of these situations are just ones that you can't control and you can't predict. And so you can do the best you possibly can to try to be the best employer and not make these mistakes. And yeah, you have that one disgruntled ex-employee who wants to decide to go off the wall and do something crazy, and you're still stuck with this.
Yes. Yeah. I mean, I have dental offices tell me all the time, like, oh, I have a great staff. I think they're amazing. And I'm like, I'm sure they are amazing, but you just don't know. And it's better safe than sorry when it comes to that type of coverage.
See, I sometimes get the opposite end of this because, of course, a lot of people will use my services kind of like they will, their services of an attorney. Not that I am one and I'm not giving legal advice, but they want to come to me to try to figure out how to get around the law. And so that's been some of the guidance that I've had to provide as well on things like whistleblower complaints, on things like workers' comp retaliation complaints. The advice that we tend to give is there's about a 6 month or so window after something has been resolved that this person is really protected. But you'll still have practices that are like, I don't like that they did this, or I feel like they're milking the workers' comp, for example. I have one story, a client, it was a couple of years ago, I guess at this point, where they had an employee who was coming out of steri, and in their office, it was a long, narrow hallway, and so they had saloon doors to their steri. And she was coming through, and there was a patient on the other side of the door who I guess just got kind of surprised that the door was coming at them. So they pushed it back, and they pushed it back into her face. And she ended up with a concussion. She ended up having to go, go through workers' comp, go talk to neurologists, and spend quite a bit of time, in doctor's appointments, and had headaches and had things that were, because this person got injured on their premises during work hours because a patient pushed a door into their face. Well, the practice owners felt like she was milking it. They felt like she was, saying that she had migraines and that she couldn't do any work on a computer, but she was playing on her phone. And things like that. And so they wanted to do all sorts of things. They wanted to put a camera on her. They wanted to give her the most menial light duty tasks. I think they had her sorting like ortho wire at one point. Different thicknesses of wire. I don't like, it was something very, very like nitpicky, tedious. That was light duty that they would give her because they were effectively hoping that she would just quit. And of course she wasn't. She, was on workers' comp and on light duty. So they kept coming back to me and kept coming to ask these questions of, how do we get rid of her? Basically, was what they were asking. Can we just tell her that we don't have any light duty work for her and send her home and then hire somebody else to do her job? And when she's ready to come back, just tell her that her job isn't there anymore. I'm like, no. You
No,
can't. You also can't bring her back and then immediately fire her. And a whole lot of other, unless she's done something absolutely off the wall egregious, like assault somebody or theft or whatever have you. Generally, that's going to be seen as workers' comp retaliation for, like I said, a good 6 or so month period after she gets released from workers' comp, not after the date of the incident, after the release of workers' comp. Not to say that they're 100% protected and you can't fire them, but you do want to make sure that you're very, very careful, have your documentation in place, and make sure that you contact your insurance company and contact your attorney, quite frankly, in this case. And that's exactly where I sent this client. I said, look, they came back to me like 4 different times, 4 different ways of how they were trying to fire this person. I said, you need to go talk to an attorney. If this is the path you're going on, I can't support that. And you need to talk to somebody who's going to CYA for you.
right. And the insurance company don't want to continue to pay her or him either, and they don't want to keep paying out. So in those situations, it's very easy to contact the claims adjuster and ask them to do an investigation and ask them, because at the end of the day, they also want to know if there's fraud being committed. So if it is a situation where they are well and they could come back, but they're saying that they're still injured. I mean, there's a lot of private investigators that make a lot of money from workers' comp fraud claims, but I mean, it's, your claims adjuster's name, number, and all that is available to you at any time. And so you can absolutely ask them to start an investigation in it. So then it's not you looking into it, it's the insurance company going into it, and they're the bad guys, not you, for sure.
That can be another risk, though, automatically assuming that somebody is milking it or somebody is participating.
Oh, yeah.
When we look at any kind of employment practice or any kind of situation, we generally want to assume good intentions until proven otherwise. Yes, she might have looked at her phone. Maybe she had a different filter on her phone. Maybe it was just not a headache at that time. Maybe the monitor was at the wrong angle, or there was a lot of other reasons why she couldn't use the computer monitor versus a cell phone. Maybe they could have done other things to help accommodate her. But they were jumping straight to the conclusion that this person was milking it and this person was committing fraud. But I see that so often. I'm in a lot of dental Facebook groups, and I'll see a lot of these things where people are just automatically jumping to the conclusion that this person is doing something wrong or is doing something negative, and that I think is a risk in and of itself. We don't want to be pushovers. We don't want to let things drag out. Like you said, there's certain circumstances where that ends up causing its own set of problems. But we do want to at least start by assuming good intentions and start by assuming that somebody is actually experiencing the symptoms they're experiencing or having whatever their experience is. I see that a lot in things like maternity cases. For example, if you're doing ADA accommodation for somebody who's pregnant, where just because one person is having an experience and saying that they're having issues doesn't mean that somebody else isn't going to have a completely different set of issues. I get that often where, well, I've asked other doctors and they say that this is not right. Or I had another employee who was pregnant and she didn't need all of this extra time off. Okay. But accommodation's a
Yeah.
case by case basis. And whenever you try to lump everybody and treat everybody with the same brush, right, broad strokes here, that is a risk in and of itself. You have to assume that this person, especially supported by a medical professional, their healthcare provider, is sending accommodation notes for the request for accommodation. You have to assume that they are truly experiencing what they're experiencing and they need those accommodations that are unique to them, because we have to treat everything case by case. Otherwise, we're
Yeah.
talking to you.
And I think that that goes to those blanket policies, right? So you get those offices. I think you were talking about one the other day, and I see them all the time too on groups and my clients too. They're like, oh, well, we don't play overtime or we don't do this. And you're like, you can't make that policy. That's not your choice.
Yeah,
I get
that's
that
a
with
whole
employee
other.
benefits. They're like, we don't cover employees until they've been here for 8 months. And I was like, well, that's not what the law says. So guess what? You do have to cover them on either the 91st day or the first of the month following 60 days. That's the law. So it's those kind of things.
There's a lot of fun little myths floating around
Yeah.
Facebook groups. I literally have an entire slide deck that's an hour plus presentation on things I've seen in office manager groups that are just wrong. And yeah, that ends up being one of them. It was the overtime. And I did actually see that recently, like earlier this week recently, where somebody said, hey, I've got an employee who is working unapproved overtime. What do I do? Well, you manage the situation, you talk to the employee, but legally you're still required to pay this person for the time spent working. But you get comments in those threads that say something like, well, we just tell them that if they're working unapproved overtime, we're just not going to pay them for that time. They're just volunteering at that point. Yeah, you can't do that. There's a 85-year-old federal law that says you can't do that.
Right. I mean, even if they're volunteering their time, they can't be doing anything that would be in their normal scope of duties. So, I mean, that's a whole issue as well.
Yeah.
Now,
And the
you
other
get a
side is,
lot of,
oh, well, if they don't clock in, we're just not going to pay them for the time that they were working because they forgot to clock in. It's like, again, you can't do that. And the burden is on the employer to ensure that you're accurately paying for time worked.
now, what about like people like when people have their work emails and stuff on their phones? Do you get those kind of questions a lot? Like when people chart at night or anything like that? Do you hear those questions?
I can, yes. And that's one of the things that comes up, especially in this remote work environment. It'll come up on things like inclement weather days. Well, we have employees calling patients, helping them cancel or reschedule. If they're working, then they have to be paid for the time spent working. And if you have an exempt employee, if they're on vacation taking PTO and you're not paying them for that week, or it's coming out of PTO, if they actually spend, and it's like 15 minutes or so, it's touch the wall rule. If they spend about 15 minutes of that week working, technically they've worked that week and they're paid for the whole week. So you have to have very clear rules about when remote time is acceptable, aside from all of the other risks that end up coming with like HIPAA and cybersecurity and all the other issues I'm sure you deal more with from the actual wage and hour side of things. Then yes, you want to make sure that you're compensating them for time worked. I think the biggest time that comes up is when you have your employee on call. We'll have some practices that are like, well, we just pay them a lump sum for the weekend, or we just pay them in a gift card for being on call. You have to actually pay them for the time spent working with applicable overtime. And it may be that whatever your lump sum is going to cover that, but you need them to track their time when they're making on-call calls or answering phones or taking notes or changing the schedule or sending follow-up emails or whatever it is that they're doing. That's work time. So have them clock that time. And if that lump sum covers it, great. And if not, you're required to pay them for the time they spent working if they're not exempt.
Yeah, absolutely. And if they get injured in their house while they're on a phone call, it's still workers' comp and it's a workers' comp claim, even though they were in their house. We've had a few remote claims like that. And then, yes, the cybersecurity has been a big issue. And we've had some issues with just blanket statements like you have to take this training, and if you don't, we're going to fire you. With the when it comes to the cyber policies, and we agree that cyber training and preventative is very, very important, especially with the amount of attacks that are going on and the amount of claims on my cyber policies lately. But forcing training. I mean, can you fire somebody after the training if they don't comply within a certain number of days, or how does that work, Karen?
If they don't take the training or if they're not complying with whatever the stipulations are in the training.
I think both. Let's go with both of those.
I mean, yeah, if somebody is not doing what you've asked them to do, if it's something reasonable, like taking a certain training, as long as you're paying them for the training time, and you should be, even if it is after hours or on a webinar or at home, it's still hours worked, it's still training time. So if they're not doing that, then that is a form of insubordination. You don't fire them for insubordination. That's a whole other conversation we've had about National Labor Relations Act in the last year or so. But you would terminate them for failure to complete the training that they've been assigned, or failure to complete the work that they've been assigned. And then if they're failing to comply past that, then yeah, you want to make sure that you're documenting it. Make sure it's not, just negligence or an accident. Have some documentation that shows that you've had this conversation with them previously and said, this is what you're supposed to be doing. You're not doing these things. These are our policies. You're not following these policies. If you continue to not follow these policies, we are going to terminate you. You want to be very, very clear of why you're terminating somebody, which is the best practice across the board for any kind of termination. And, again, we're talking about root of the risk. We're talking about wrongful terminations.
Right.
Lawyers, Department of Labor, unemployment offices, EEOC do not like to hear that an employee was surprised that they were fired. And so whenever you have this guidance that you'll get where, oh, well, we're just going to tell them it's just not working out, or it's just not a good fit. We're not going to really give a reason. We're an at-will state. We don't have to have a reason. Oh. You open yourself up to massive liability there by not actually giving a clear policy violation, misconduct, some true legitimate reason why this person was let go. And it doesn't matter if it's misconduct. If you just basically say, well, we're just going to let you go, then that opens them up to figuring out all kinds of reasons why that you were let go. And it ends up usually being because I was a member of a protected class and I'm going to go make a filing for this, or because I was a whistleblower, or because I was whatever. I pointed out that OSHA violation and they fired me for it. There's going to be a myriad of reasons that they'll come up with because everybody feels like they have a right to sue.
Yes. Yeah, they absolutely. And we've found that there's a lot of juries out there that are, just jury pools, and this as social inflation has gone through the roof. So when they do go to court, some of those settlements have been very, very, very high lately. So
some of them in later on, they will get overturned whenever they get overturned upon appeal. Some of those massive settlements in the very beginning do eventually get overturned upon appeal or get reduced further up the court system from the reading that I've been doing on this. But yes, at least initially, there are some very large, very generous sums coming from some of these juries in the lower courts.
Right, which is what, you can't go down a road without seeing all the billboards in the state. So then that's what leads that open to more lawsuits and more employees thinking that, it's an ongoing battle. It's the same thing with, patients and malpractice insurance. We've seen some nuclear verdicts much higher than we have ever seen. And situations where, I know this is wrong to say this, but where the patient is alive and didn't pass away. And, it was from a numbness from a root canal or, just in $10 million verdicts. And they're just shocking. So.
Well, and malpractice is one that I don't typically have to deal with often, but on the side of things, we're talking about things like training, for example, training and making sure you're actually supervising and monitoring and ensuring that employees are doing what they're supposed to be doing, because your malpractice counts for them too, right? If a hygienist, for example, does something and injures a patient, or if an assistant injures a patient somehow, that's why you have malpractice. It's not just for your own practice, correct?
Correct. Yes. Yeah. All non-dental associates fall underneath your personal malpractice insurance, and they're covered under it. So the assistants, the hygienists, even the office managers would fall under that. So it does. Oh, let somebody else in.
Got it. Go ahead.
Yep. Those also. So you want to make sure that they're aware of the risk management practices. They're aware of the consents that need to be done. You have to make sure that everybody's reporting things correctly after it happens, that you're charting correctly. Absolutely.
From the insurance side, I've had one of these cases happen recently where an employee had picked up something sharp in the lab, and they weren't picking it up the way that they were taught to pick it up. They picked it up incorrectly upon further investigation. And it was based on, training that they should have had, but they weren't doing that. How do y'all tend to handle that from the insurance side?
Yeah, it's still a workers' comp claim. So you still, any kind of prick, you still go get, it. You absolutely go get a test for that. You file that in case anything were to come of it. But, we do, 100% say you need to retrain, and you can't, just like you said before, if somebody's not following proper training and protocols, that's up to your discretion as far as documenting that further down the road. But that doesn't exclude them from the policy, even though you had that in place.
We have an interesting question in the chat. And by the way, if y'all have questions, y'all are welcome to drop them in chat.
Yeah, absolutely.
Do our best to answer them. If you're utilizing a temp agency, do they usually carry their own malpractice for the employees, even when in my office?
Okay, so super fun. So if you think that they're carrying liability, they might not be. So a lot of the temp agencies believe that the dentist has their own malpractice and that any temps working under them are going to be covered under them. So there are several out there that do have their own malpractice. They're going to advertise that they have it, and they should provide you to be able to provide you with a certificate of insurance upon request. So if their website says that they have it and they can show proof of it, then absolutely they have it and you should trust them. Most of those situations, they're only going to be covered when you're booking them through that temp agency. So whether it's one of the online temp apps like Cloud Dentistry or TempMe or TempStars or one of the, and I'm just naming, in general, just those online booking ones, or if you're getting TempStars from a temp agency in town, you just need to make sure that they actually have that coverage. And because sometimes they assume, in fact, I know this because we insure some temp agencies. There's several others that just assume that the dentist is going to be covering the malpractice. And they will even tell the temporary people, oh, it's okay, the office will cover you.
So what about if it's a temp that is just a friend of the hygienist or a friend of yours, maybe a
Yeah,
former
they're
employee
still going to
back?
they're still going to be covered under that dentist malpractice insurance, the office malpractice insurance, depending on who it is. And so that's the question is, do you want to share your limits with somebody who doesn't always work with you? Because they do share in your limits, and that patient that you see, that you are going to be covering them because they're an employee of yours.
The other concern you run into with temp agencies is a co-employment situation. There are some of these laws and some of these things like ADA accommodation, if you're a larger practice, if it applies to you, that if you have a temp and they're working, long term, in ADA, it's actually day one, working long term, there may be some co-employment liability there, as well as some co-employment responsibility for certain accommodations and certain things. And so that's another thing to be aware of whenever you have a temp agency that you're working with. To follow up with this question, there was a very specific situation where a temp hygienist burned a patient's lip and it swelled severely. I was curious if the patient came back and sued, who would be responsible?
So it would still fall under the dentist malpractice insurance, the dentist that they were there to see, because the way that the medical malpractice policies is, it covers the dentist practitioner and all the assistants and hygienists underneath them. So then that's whose policy would pay first. Now, if the hygienist had their own policy or there was a separate policy in place, especially if it was through a temp agency and there was a separate set of limits, then their policy would pay first and the dentist would pay secondary. So you find that there's, if like in certain states, there's different types of sedation are allowed, and the scope of practice is different, varying on the states as far as what hygienists do. And so if some of them are doing sedation, we recommend that they carry their own set of limits, even when they work for, so that a dentist, so that you're not sharing in those sets, that 1 million, 3 million, or that 2 million, 5 million, that you each have. I mean, basically I say it, you each have your own lump of your lump of money or bag of money. If a patient were to sue, and theirs would pay first and yours would pay secondary.
Nice. There is another question, and it's referencing a specific company, but there's actually several out there. What about the agencies that claim that they're not temp agencies? And I've had a couple of those from the employment side, from the HR side, where they're a referral or a placement agency. They're not really a temp agency. You're still paying the worker directly. You're not paying the agency. So it's not really a temp agency, even though you're hiring a temporary employee. So I've had like a client, for example, bought a practice that had a hygienist who worked 1 day per month, literally 1 day per month. And this was in a city that had a sick leave ordinance. And that's what we were trying to figure out. And they said, well, I mean, she's a temp. She doesn't get that. I said, well, do you pay her directly or do you pay the agency? Well, we pay her. Okay. Can I see that contract? Page 1, quite literally, says we are a referral or placement agency. I say, congratulations, you've hired yourself a part-time hygienist. And yes, that's
Exactly.
what you're required to pay the sick leave for.
Yeah, no, absolutely. What do we say? If it walks like a duck and it talks like a duck, then it's a duck. And so unfortunately, in those situations, especially from a workers' comp point of view, if that person is a temporary employee, whether they were through an app or through an agency or just directly, they're going to include them in your workers' comp. And they're going to cover them under your malpractice insurance, unless now there are some temporary agencies and some of those apps that have their own OCO and workers' comp policy that covers their temp workers when they're working there. But again, you want to just show proof that they actually have that in place.
That's, I think, one of the, if we're, again, talking about root of the risk, that's one of the risks that I see pretty frequently is that we are paying our temp employees as contractors. We're cutting them a check at the end of the day because that's what they're asking for. And we're not running them through payroll. We're not getting the proper I-9 and W-4. We're not making them employees. And based on what in most states, what the temporaries we're hiring do, they don't really qualify to be 1099 contractors. But one of the reasons I give for that is because of the insurance side of things. If you've got somebody who's not really an employee who comes in and gets injured on your practice, that could be a problem with workers' comp. Workers' comp, to my knowledge, may not cover them. It can also be a HIPAA violation. It can also be a wage and hour violation. There's a whole other like laundry list of reasons why it's a bad idea. But if you're paying that person directly, truthfully, they should be an employee and you should actually hire them as an employee, even if they're only there for a couple of days. The length of time does not necessarily determine contractor versus employee. And I know there's some new laws out for contractors that may or may not get overturned. This is going to be an interesting year, quite honestly, all the way around, just given the political climate of the year.
Calling those the Uber laws? Is that what we're calling like the Uber Lyft driver laws?
Yeah. And it depends on what state
Image license. Yeah, the name, image, likeness for the college athletes is going to be another one to look at. No, I think the same thing that you're saying with the contractors versus employees. I think that's a really, really fine line. And a lot of times when they're contractors, they don't get to make their own hours. They don't get to come and go as they please. They don't control their schedules. They don't control who they see.
But the practices try to pretend like that they do. And it's not black and white. There's a lot of shades of gray here. But for example, if they have an associate that they're paying as a 1099 contractor and they say, well, they get to pick what days they want to work. Yeah, but they're not really picking the hours. They still have to work the hours that the practice is open. They don't get to come in and work on patients at midnight. They don't get to keep their patient files. It's not their patients. They're not using, they're using the team. They're using the tools. They're representing themselves as a member of your practice. They're a W-2 employee. And same with even a temp employee, a temp who's coming in for hygiene or for assisting or front desk, they don't have an opportunity for loss. They're still economically dependent upon the practice. They're not running their own business effectively. They're not allowed to in most states, at least for hygiene anyway, to run their own business. There's like 2 or 3, I believe, that allow that. But for the most part, that's not their business. They're just coming in to fill in as effectively doing the work that you're assigning them, working on the patients you're assigning them for patients of the practice. So they're a W-2 employee, even if they're only there for a day. And I've seen us personally, not my clients, of course, but I've seen personally in dentistry practices that run into a lot of issues with that because they're misclassifying. And oh my gosh, believe me, you do not want to deal with an IRS misclassification lawsuit. It's a lot of fun and very expensive.
And there's a lot of associates who want to be paid as an independent contractor for accounting purposes, but what we say is, and you still need to include them in the workers' comp, you still need to include them in the employees' benefits, you still need to include them in the group malpractice. That's an accounting end thing at the back end, and they're an employee. Right.
And they don't get to dictate that is the thing. The problem ends up being on the practice. So one of the misclassification suits that I worked on back in 2019, we were working for the year of 2018. This was back when I had worked for a CPA firm, a dental CPA firm. We had just taken a new client, and like 2 weeks after we onboarded them, they get this letter that says, oh, by the way, they're being audited for the prior year. They had 5 practice locations, about 15 associates, and 13 of the 15 associates were classified as contractors. And what the IRS was looking at was quite a few things. They were really looking at whether or not this person, this worker, it's worker classification, so I'm going to call him a worker, even though I don't like the word, this worker had the opportunity for loss. And they had contracts for a lot of them, not all of them, they had contracts for a lot of them. Some of them were even S Corps, but they were determined to be employees because the practice was basically feeding them patients. It's not like they were renting a chair and having to bring their own patients and bring their own team and their own supplies. They were just showing up to work. They were doing what we call the business of the business. And so they were W-2 employees misclassified as contractors. And so the practice ended up having $142,000 that they owe the IRS in fines and back taxes. And they tried every which way. I said, well, the worker paid taxes too. Doesn't that count for something? No, it doesn't. So they ended up like $142,000 and they were trying to sell this practice at the time. So that was a bit of an interesting little situation there. But that's what they were looking at, is whether or not they had opportunity for loss. These people were also getting benefits. It's another thing they looked at. And I think one of the bigger, more obvious things is that the contract came from the practice to the worker and not the other way around. If you're truly trying to say that this is a 1099 contractor that's running their own business, and there are legitimate situations where that is the case. If they're doing specialty, for example, if they're doing like endo and coming to a general and that's their business, is they go to different general offices and maybe go 2 days a month or something to do endo, that's an actual genuine 1099 situation.
Right.
Because
Where they set the schedule, they come
correct,
in, yeah,
correct. But the
absolutely. That's
contract needs to come from the endo to the general. It's their contract. The payment terms need to come from them. They need to send an invoice. If you're putting a 1099 on your payroll, that's already kind of saying, they're more of an employee. That's not how that works in a true contractor arrangement. And I use myself as an example. I am a contractor for dental practices. Whenever I provide HR services, that is not something dental practices provide. I am providing something to support their business. I do it on my terms. I send my contract that they sign. I send an invoice that they pay based on the terms, presumably, that I put on the invoice.
right.
And that's a true contractor arrangement. It's not what's happening whenever you have a temp coming in for a couple of days to do hygiene.
Right. Yeah. So there was a comment. I have a sub list that I organize. Offices do not pay me for any of this. Employees don't pay me. Do I need to stop? Eek. So you're the matchmaker. Is that what we're saying?
Yeah. Referral or placement agency at that point.
Should you stop doing that?
Should
I
you
don't.
more policy and contracts in place? It's more like,
Yeah, more policy and contract. I mean, is it the same as saying like, oh, this hygienist that has a friend who's a hygienist, and so I don't know that there's as much. You talk to that. I don't see the matchmaking you're in that situation having as much liability.
not as much, but it depends on how you're representing yourself. If you're saying
That's true.
I have a sub list and just let me know when you need people and I'll send somebody to you, then that could be very well seen as a referral replacement agency. And if you're going to do that, then I would certainly have those agreements in place and make it very clear. And also make it clear that if they're paying that person directly, that this person needs to be correctly classified and it's on the practice to make that determination. Don't, like some temp agencies do, say that this person's a 1099. In some states, there are some agencies that have found what they call a loophole. They say their attorneys have looked at this. I say my client is still going to be liable if they do this, where the worker is not providing services to the temp agency. They're providing it to the practice, but the practice is paying the temp agency. So they're saying they can be a 1099 because the practice doesn't pay the worker directly and the worker isn't performing work for the temp agency. And so this is supposedly this little loophole, which does not work in every state, by the way. But at the end of the day, this person has performed work for the practice, and the practice, again, if you have somebody who gets injured or if they injure a patient, I think there's massive liability in trying to take on that risk just to save a couple of dollars and save some time on payroll taxes. So that would be an interesting little situation too. So yeah, if you're using something like this or setting something up like that, I would make sure that you talk to somebody and get some structure to it versus just saying, here, I have somebody who wants some extra hours.
Yeah, I think what she's saying is that they have a local Facebook group where they just keep the list up.
Which looks like you're referring people. It looks like you're advocating for them. I don't know if you're vetting them or not. I would really get some structure in place for that. And if you have people that or practices that you're sending these people to or letting them know who's on the sub list or who's available, make sure you're representing yourself correctly and make sure they're paying those people correctly. If a team member trips and falls due to no fault of the employer, is this a legitimate workers' comp claim? That's a good question.
Yes. Yeah. If it happened at your office, the answer is yes. If it happened while they were at a convention or CE during convention or CE hours, yes. If it happened in Vegas while they were at the slot machines, not during the convention time, not during an organized dinner, then no. But otherwise, yes. It's
if
really
it happens when they're working from home.
Yes.
Why some workers' comp companies require photos of the workspace and certain
Yep.
workers, that we don't always think about. We think about the cybersecurity and we think about the HIPAA. We don't always think about the workers' comp side of having employees work from home.
Right, exactly. And depending on the states, because I mean, they can say that the employees can say they're in one place and they're actually not in that place because they're in a van,
Oh, that's a
200
whole other
miles away
issue, by
from
the
there.
way.
That's a whole another issue. But no, yeah, absolutely. Even if it's, it wasn't a slippery floor, there wasn't a situation, that's still a workers' comp claim, and the workers' comp is going to protect them under the state laws.
Yeah, the other side, I know this doesn't happen a lot in dentistry, although I have some clients that have like remote office managers or remote billers, for example, that they're employees of the practice. They just happen to work somewhere else. If that person decides to move to a different state, you have to go and file as an employer in that state.
Yes.
In some states, you have to file for a business license. And even if they're just traveling, I actually had a client that this happened to. They had they were based in Pennsylvania. They had somebody who moved to California. They didn't file as a California employer, which could have ended very, very badly. I think they managed to work it out without too much of an issue. But they had somebody who moved to California, and then they decided they wanted to kind of vagabond and do like 30 days in the state and another couple weeks here. And states have temporary residency laws where, if you're staying more than X number of days in that state, they consider you to be, a resident of the state, ergo you're employed in that state. And so if you have employees who are deciding to work kind of randomly remotely and not telling you, I would make sure that your IP can track where they're logging in from. Because if they're working from a state that you're not an employer, you're at risk at that point. Um,
And the same thing with workers' comp. You have to add those states to your policy. And then there's 4 states where they're in a monopolistic state. So you actually have to buy a separate policy from the state. Like Washington State is one of them. So you can't add them to your Master, Hartford, Zenith, Liberty Mutual, whatever carrier you have policy. You have to buy a separate policy for it. It's a whole thing. There was a question in the chat, and I know that we're wrapping up because we wanted this not to go too long. So, but if you lease a space from a landlord, who is liable to carry the slip and fall insurance in the parking lot? Okay. So there's a lot of discussions about this, but as a tenant, you have general liability, and the building owner should also have general liability. But if the patient slips and falls after they come out of your chair, it is a malpractice claim because you saw them before they slipped and fell. So if they're walking into the office, you could argue that it's the building owner. If they're on the curb, then it's your policy. But if they came from your chair, whether they tripped over a parking stub or whatever, it's still going to be considered professional, and it's going to fall under your malpractice. We actually had a situation where a assistant put somebody in a chair, the lamp above burst, cut the person's face with like the shards of glass from the light. The dentist never saw them. They went to the emergency room right away, but it was a malpractice claim because their butt was in the chair, even though the dentist never even walked into the room. So, and professional services are specifically excluded from all general liability policies.
wow. Okay, then. Oh my goodness. So one of the things I've been talking about lately about some of these simple mistakes that have been made by a lot, we've noticed, I think over the last couple of years that associates coming out of school, hygienists coming out of school, dental assistants coming out of school aren't as trained as they have been in the past. And that is creating some problems for sure. Even the ones, quite honestly, that say they have 20 years of experience, do they have 20 years of experience? Do they have 1 year of experience 20 times over? Are they really learning and growing and better than they were when they first started 20 years ago? One of the problems that I see often in hiring is that practices want to conduct a working interview. And problematic for many reasons. One of them being effectively you've got somebody who's a temp employee who they're not really hired. And so again, there's liability insurance reasons, there's HIPAA reasons, there's a lot of reasons, pay a wage an hour that we don't want to do working interviews. However, what I end up recommending is a skills assessment. And the reason I like to do that over a working interview, aside from all the liability risks, is that to me, working interviews don't necessarily tell you what you need to know about this person. It depends on who the patients are, what the treatment is. You may not know that this person can't do something that you need them to be able to do, because for one, they're not always watched very closely in a working interview, which I find comical. And for two, they may not have just encountered the situation. So I had a client who was hiring an assistant. This was an ortho practice. And like she was supposed to be coming in as the lead. She was getting paid more than the people he already had there. And he finds out like a week or so into her actually being hired that she didn't know how to take an impression. And he's like, we did a working interview. I don't know how we didn't know she didn't know how to take an impression. Well, it's because every time there was an impression that came up on the schedule, she handed it off to another assistant and she never did one. So she didn't prove that she could do it. So rather than have them come in for this, working interview nonsense, have them come in for a skills assessment, whatever the position is. You have a specific checklist of things that they actually need to be able to do, or it doesn't necessarily mean they have to have mastery of the skill. You just need to know at what level they are at. So if they say they have experience with your practice management software and it's front desk, for example, have them get into the dummy account, have them read out an EOB, have them respond to a letter from a specialist that's redacted, of course, to see, what their communication level is. Make sure that you're actually assessing these people, because if you hire them and find out they're incompetent, that's not going to hold up for unemployment, for one, and for two, it is a massive liability for you on your own practice insurance, among other things. They're coming in and they're making these mistakes that you could have easily identified by just doing a 60 to 90-minute skills assessment. So I like having them come in like in mid-morning, do a skills assessment, stay shadow for a little bit, have lunch with the team so the team can give feedback, have this be like your last top two candidates, for example, so that you're really getting an idea of who this person is, how they interact with the team, and can they do the things they say that they can do, so that whenever you hire them, you know what you're getting.
Yeah, no, I 100% agree. I don't like working interviews for liability reasons from both sides of it, from the associate or hygienist or, patient abandonment, just the whole gamut of why I don't love that from a liability standpoint. And I do think that shadowing will tell you a lot too. It tells you a lot about how attentive people are, how quick they are, what their knowledge is. I mean, you can get a lot of that without having them be, and like you said, people aren't in the room with them, which is just even scarier. So
I just had a client, actually, she onboarded somebody, and part of her onboarding process, this is literally like this last week, part of her onboarding process is she wanted this person to shadow for a couple of days and really learn their process. And it didn't sit well with this person. I don't know if I would have hired them originally if this had been communicated and they said they weren't comfortable with it. What they told her was that they learn better, by doing. And that's great, but this is a different type of practice. This is a practice that's fee for service. This person had come from a PPO practice. The way she talked to patients was different. The way she did things was different. And like literally on day, I want to say it was like 2.5 or something, she was already trying to change systems. Like she was unchecking the box that sent text messages to patients for reminders. She was grumbling about the fact that they called patients for reminders. Little things like that might have come up differently had the questions been structured differently in the interview. And my client knows better for next time. But it was one of those things that just by asking her to shadow, and the fact that she was unhappy just watching how things were done and learning how it was done in that practice was very, very telling to me. So that's a to be continued on how that story ends. I'm not sure yet. We'll find out. But had we done, a different type of interview, and had we done a little bit more communicating or being a little more clear up front of this is what our process is for onboarding, you need to learn our culture, and we want you to see how we interact with patients, and have you really sit here and absorb versus jumping in and doing, that there would have been less of an issue, I feel. So again, lesson learned for next time.
And I think everybody, really wants to get a warm body in a position because you stretch your other team, is stretched a lot. And we're asking, and it's not just in dental practices, it's everywhere. We can, sometimes we're short staffed, we're growing so fast. And I have to, and I tell my team members all the time, I'm like, I want the right person and you want the right colleague, and not just a warm body, because it's more work in the end and it's more pain in the end, that you just have to really stick to your guns and go through the process and find the right person for sure.
And then you're starting over. You're not going to know this usually for about 3 days to 2 weeks that this is not really a good fit. Sometimes you try to drag it out because you don't really want to have to go back through that process again. Your second candidate, your top two candidates, that one person's already taken another job somewhere else. And so you're really starting over again. And so we keep trying to force the wrong person to stay in the wrong seat, going the wrong direction. And it just ends badly for lots of people. In my world, it often ends with them coming out and saying that, they need an accommodation, or they're pregnant, or there's something that comes out that's, for some reason, every time somebody says something, not every time, but still maybe 80% of the time somebody asks for an accommodation, I get feedback from the practice. Well, we were going to fire them anyway. But we didn't. They weren't doing this. They, had these issues. We were going to write them up for something last week and we never did it. And it's like, okay, but you can't now.
Yeah, you can after the fact for sure. No, the trend I've been seeing a lot lately is pre-dental students working at dental offices, and a lot of pre-dental students are trying to get into dental offices to make sure that whether they're going into hygiene or assisting or dental school. and just really getting a good idea for the office. And we find that those seem to be filling a lot of vacancies too.
Oh, it's great. I love that they do it. Now, that being said, there's usually an end date because
Oh, yeah,
they're going
there
to,
is.
but I think it's great that more people are wanting to do that and get that experience before they really make that commitment to going to, hundreds of thousands of dollars in debt.
Yes, absolutely.
I think even hygiene programs are kind of getting that spendy.
Yes, there are some very spendy ones for sure.
Okay, we're getting close to the end of our time. Is there any other questions? You're welcome to come on and ask them or drop them in the chat, either one. Be happy to answer them. Any last words from you, Carrie?
Well, I know we didn't touch on all the different insurances, but I will tell you because I keep getting calls, please make sure you have a very comprehensive cyber liability insurance policy because dental offices are being attacked and it is now about 2 to 3 weeks that you are out. It like that's about average of how long the office is dead in the water until they can get back up and running. And so I'm sure you have wonderful IT people and we love IT companies, but if they tell you they can get you back running in 30 to 60 minutes, they are wrong. Even as much as they really want to do that, they cannot just unplug you and restart the computer. So it's
When
been
you
really bad
when
lately.
you say comprehensive, sorry, last question, and if anybody needs to drop off, I totally understand. Last question. When you say comprehensive, I don't recall if it was our conversation or a conversation with something with somebody else that there are certain cybersecurity policies that aren't paying out if the practice doesn't do XYZ. Like
Yeah.
there's limitations to them paying out, and you get into a situation where you don't even realize that you should have checked a certain number of boxes. What are those boxes, and what are the things they need to know about cyber insurance?
Yeah, absolutely. So you do have to make sure that you understand any conditions of your policy. So there are several policies that require that you have multi-step authentication, that you have a firewall, that you have a VPN, things like that. But you want to make sure you understand what all those requirements are up front. When we say a comprehensive policy, we want you to have a policy that has two parts. You want it to have first party coverage, which covers you. So it's going to cover the ransom, it's going to cover the business income, it's going to cover to replace your computers, your hardware, it's going to cover to notify all your patients, so the breach notification that's required under HIPAA. The forensic investigation costs. The second part of it is the third party liability, which is when the patient sue you because your patient information has been hacked. So that's the part where it's actual liability. The lawsuit is that you compromise their patient health information. So you want to make sure your policy has both parts and it's not just data breach coverage and doesn't have the liability portion. And that it's not just added on to your malpractice for 10,000 or your office policy for 25,000. You want to make sure you have a set of limits. And when we say what set of limits, we usually say whatever your monthly revenues are, you want to have at least twice that in liability limits.
That's a good number. Interesting. Good to know. And then on top of that, you want to train your team and make sure that they're aware of all of these things and are transparent with them so that they're following the policies and following, just like I said, checking all the boxes.
Yep,
I run in that.
boxes,
Mhm.
not clicking all the emails, not paying invoices from emails.
Yes.
I had one the
Well,
other day where it was a lab bill, and instead of the being an L, it was an uppercase I, and they wired hundreds of thousands of dollars to an account in Russia. So
nice. Excellent. Okay. To top on that one, make sure you have that written in your employee handbook as well about what happens if they're not following these policies, because you want to be able to take the necessary steps that you need to. I mean, that honestly could be said for just about anything. That's one of the reasons I'm a huge advocate of a comprehensive employee handbook. And when I say comprehensive, I don't mean one you got off Facebook from a friend or from somebody else at all, or like you said, the sellers. I want to make sure that it's something that really fits your practice, that covers everything you need for your specific situation, and will help protect you in the event that you have employees behaving badly. We had one last question. What happens when a temp does not get OSHA training? Carrie?
oh, what happens when a temp does not get OSHA training? Well, the way that OSHA training works, you need to do it like in a reasonable time. So if they're just a one-time temp, that's not going to be as big of a situation as if it's somebody that you do bring back from time to time. You are going to have to take them through the training just like you do all the other training, including your HIPAA training.
Mm-hmm. Okay, fair enough. Well, awesome. I've enjoyed our conversation. I knew we could talk about this for at least an hour.
course we could.
Thank you all for attending tonight and for your great questions. This has been a lot of fun. I would love to do this again at some point because I think we probably only touched on about half of what we could have talked.
Right, absolutely. But I'm sure we'll get together and see each other, and I'll see everybody at dental shows. If you see me at any dental shows, please come up and say hi. I'm definitely around this year. So,
Sounds like
but
fun.
it was nice to see everybody. And if anybody needs me, let me know.
So I'm going to drop her email in the chat and then I will put mine as well. You are welcome to reach out if you have any questions. Mine's Carrie at clinicalhr.com and she is carrie.millar at fdaservices.com. Thank y'all.